Welcome everyone, Rosie Sullivan here from Australian College Professionals, and really happy to be here today with two marvellous people from our industry. And what we're going to be talking about is a very, very recent case through the through NCAT, through the New South Wales Civil and Administrative Tribunal. And that case is about a commission review and what happened with that particular case. And I guess the very quick summary of it, and I will go into a little bit more information in a moment, but the vendor wanted to, did challenge the payment of a commission after a property was sold. And the ins and outs of that whole scenario is what we're going to be talking about today. And I guess the bottom line is, and we'll come back to this a couple of times, the bottom line is it is still so important that your documentation is absolutely spot on when it comes to preparing that and presenting it at a tribunal or in any jurisdiction at all. So super important to be doing that. So with me here today, in person, I have here with me Lisa Jemison, who was the solicitor acting on behalf of the listing agent in this case. Lisa is a partner and she steers, I don't know whether it steers, but certainly manages and I think steers is a friendly word.
Possibly.
But controls and makes sure that everything goes according to the way it should be in the busy litigation department at Jemison Fisher. She deals with a wide range of litigation matters every year. Now, almost every single one of those litigation matters is on behalf of real estate agents. Her knowledge, her perspective on how to support real estate agents and making sure that what you're doing every day is not questioned, is seen to be the exact compliance of what an agent should be doing. So when she actually looks at those, she's looking at that from a real estate practice point of view, from a qualification point of view, from an experience point of view. So it's a huge deal. I mean, Lisa's cases range from employment law through to defending insurance disputes, negligence action, staff fraud, unfortunately is an issue, franchising disputes, right through to what we're going to be talking about today, which is about commission recovery or commission claims or commission questions. So Lisa, with her Master of Laws and membership of both the Queensland and the New South Wales Law Society, is an amazing font of knowledge to share this latest case that she acted upon. So thank you, Lisa, for coming and sharing with us. Now, we also have, via the marvellous technology of online, we have with us today Ben Spackman, and he is one of the Northern Beach's most genuine and approachable experts in all things real estate on the Northern Beaches. He's been ranked in the top 100 agents in Australia and certainly #1 agent in Mona Vale for many years. So he's backed by the brand of Rain and Horn, which is, I think it's in the 1800s, Rain and Horn has been around since. So that's a big call there. So he's got all of the tools. So when he's acting on your behalf, or anyone within his agency is acting on the behalf of a vendor, they're getting exactly what they need to do and get the best possible offers on properties. So as a top agent, I think the list of awards, Ben, is amazing in terms of what you've achieved over the years. And he's local to the Northern Beaches. He's passionate about what he does. He's passionate about doing the right thing by his clients, be they vendors, landlords, purchasers, tenants, right across the business that he offers in the Northern Beaches area. So it's actually set him up as an agent who is a professional, who is an expert in his field. Unfortunately, sometimes when you are at that level, Ben, it means that vendors, clients, members of the general public will want to question what you're doing. And I guess that's what this has happened this time around. And we're going to look through what the application was that went through to NCAT. And, when we actually look at this application, it was about a signed auction agency agreement, which happened only last September, so September 2021. So in terms of the orders that were issued on this case, which was March 2022, it was really only a 6-month period, which is really quite a speedy matter in terms of an NCAT outcome. So it was about the vendor being granted or exclusive rights to the property for a fixed period. So, or the selling, the vendor had granted, exclusive rights to selling that property for a fixed period. The question was, when the vendor then took that agency or that agreement to another agency, they signed up. And we all know, everybody who would be watching this video knows about the warnings that are contained within an agency agreement, knows that there is, if you sign another agency agreement, there is a warning as per the regulations that needs to be in there, warning the vendor about the possibility of paying 2 commissions and the possibility of penalties that come that way. So Lisa is going to share some more about this case with us, and looking at that exclusive selling period, looking at what is in the agency agreement, looking at how that and the completion of all of this documentation and the record of what went through on a daily basis, and actually putting that into your CRM, keeping records, keeping your texts, downloading those into your database is such an important part of protecting yourself. So as an agent, that's super, super important. So Lisa, do you want to give us a little bit more of a summary of what happened in this situation? And again, focusing on why Ben was successful in terms of the way he kept his documentation together.
Okay.
So I probably should, I know I interrupt a lot, but I probably should say this is a case that Ben and Lisa won. So that's the really important part, that this is backing up the agent who has done the right thing. So Lisa, give us some more. So congratulations, guys, on winning, and let's hear some more about it.
Okay, thank you, Rosie, and thank you, Ben, for joining us today. So today we're going to run through the mechanics of a commission claim, and the context is that the agency, which is Ben's office, which is Rain & Horn at Mona Vale, entered into an auction agency agreement with a vendor, and as you'd be aware, that's an exclusive agency agreement. The agency agreement that at the point where it was entered into came with all the required checklists and forms, and that includes your material fact checklist as well as your consumer guide that provides additional warnings and information to vendors. Rain & Horn Mona Vale are a large and successful agency, and that doesn't happen by chance. And there are a lot of systems and processes and procedures that go into that agency to ensure that everything runs smoothly. And Ben's very lucky to have his wife, Katie, in the business, who is a stickler for paperwork, and she keeps everything in check, so to speak. So a process was developed at Ben's office whereby when they were presenting agency agreements to their vendors, they would send it over via email, and then that way they considered that the vendor would have the opportunity to read through the agency agreement and understand it, have time to consider the material fact checklist, and also read through the consumer guide. Then after that was done and completed, then the agency agreement would be executed and signed, and it would still also come with a cooling off period that was extended to their vendors. If we stop there in relation to the agency agreement, Ben, perhaps you could just give some outline about the background of what was happening at this time, because this vendor was also a prospective purchaser within your office as well.
Yeah, correct. So at the time, it was a pretty booming market and things were moving pretty rapidly. And this particular vendor had a personal relationship with one of the agents in the office, went to school together. And he'd actually enlisted that agent to list the property after, obviously, he bought the property, another property through us. But what had happened is basically he'd purchased the property from us, and then he'd pursued to move on to signing an agency agreement. And as Lisa said, we go down a path of we actually DocuSign and email those over to the vendor so they can review the document prior to signing. And he progressed to do that. And then literally 2 weeks after that, there was discussion throughout the 2 weeks leading up to prior to him pulling out of the agency agreement or attempting to pull out of the agency agreement, that he was preparing the property for sale. The contract was being ordered. The contract never arrived. And then around that 2-week mark, he decided that he was going to give the listing to another agent in the area because of a personal relationship with a parent. And that's where we kind of moved into action, knowing a little bit around the protections of an agency agreement and what your rights are to claim the fee.
That's right. So at that time, the vendor contacted you and said to you that they sought a release from the agency agreement.
That's correct.
And there were findings made ultimately in the tribunal around evidence on this issue. And that included that an approach was made and that you explained the contract again to the vendor, and also highlighted and brought to the vendor's attention again that they were subject to an exclusive agency agreement. And if they went ahead and listed it with the other agent, that they could be liable for 2 commissions. And what did you understand from the vendor was happening with the other agent?
Yeah, so obviously it's a really competitive industry and we list a lot and sell a lot in the area. We'd warned the vendor 3 times, verbally, text message and email. So he had ample opportunity to do the right thing, but he progressed with the other agent either way. Now, the reason that he progressed with the other agent is that they had basically given him a warranty that if our office were to sue him for the commission upon sale, that they would cover the costs accumulated for that.
That's right. So that's a very important point, and it's important and unique to this decision, the arising of the indemnity given by the second agent. And so evidence wasn't led by the second agent in the NCAP proceedings, nor was the indemnity that was given to the vendor put into evidence, but we did get some information in cross-examination from the vendor. But the indemnity, essentially, as we understand it, was the second agent looked at the agency agreement that the vendor had entered into with your agency at Rain and Horn at Monaval, and considered it and then said to the vendor, no, you don't have to worry about that. And if you are worried about it, we will give you a full indemnity so that if Rain and Horn sue you for that commission, we will pay and cover those costs under the indemnity. The second agent then entered into another exclusive agency agreement with the vendor and ran it through, I think it was an auction campaign, but nonetheless, they sold it. And then at the point of sale, Ben, what did Rain and Horn do at the point of sale?
Yeah, at the point of sale, obviously, we contacted you and started the process to recover the fee. At that time, I think we issued a Section 36 to progress. Yep. Once the vendor had received that, they moved on to an NCAT mediation or hearing in regards to the review of fee.
Yep. So for the listeners watching, the agents are required, once the property settles, to issue what's called a Section 36 notice. And that essentially is a claim on the vendor pursuant to the agency agreement. And a Section 36 notice gives the vendor 28 days whereby they can apply to the New South Wales Civil and Administrative Tribunal, NCAT, for a commission review. And they can go along to NCAT and put their case forward to a member as to why the agent's commission under the contract should be reviewed, and NCAT have got the power to reduce the commission to 0 or to reduce it by half, and the agent must respond to any action in NCAT. Until the 28 days has passed, the agency can't take any legal action on the contract. So they can't commence in the local court for debt recovery or in the district court, depending on the amount. They have to wait out this period of time And then after that time has elapsed, the agent can be the plaintiff in the local or district court. In the alternative, the vendor makes the application in NCAT. In this case, the vendor did make an application and sought a review under Section 36 of the legislation, and it was accepted that it was a consumer claim, and Rain and Horn was given leave to be legally represented at this hearing. Now, Ben, we, as a co-principal of Rain and Horn and your work in running the sales office, you gave an affidavit in these proceedings.
Yes.
Maybe you want to give some feedback to agents watching how tumultuous it is preparing and going through affidavits. How much fun is it?
Yeah, look, it's not fun at all. And reality, this is the first time that we've ever had to deal with a case like this. We've never been to NCAT before. We generally have really good feedback from clients. So it was a surprise when it all sort of came about. And the whole process is it's taxing on the office. It's taxing on the selling agent. It's taxing on us because we're managing things outside of what we're used to, which is listing and selling property. And the whole process, as far as an affidavit's concerned, it's painful and slow. I think that no matter what, whether you get reimbursed the fee, the full fee, plus legal expenses, it still costs the office. It's also painful for the selling agent because there's a delay in commissions. So the whole process itself is not fun.
That's right.
And that's not to mention the emotional and the, I guess, the mental anguish that you're going through
that
at
as
this
well
time.
as,
And that's it's just yet another bad side product of it.
Yeah, and obviously there's the concern around feedback that those particular clients are making in the public arena, and we've got a pretty good reputation. Being on a peninsula, it's a small place, and reputation is everything. So we were very wary of that, but we also made the decision, like we're upheld by agency agreements. So when it goes against us, we should lean on those agency agreements to protect our fee.
Can I just clarify something here for people watching this? That the property was actually sold within your exclusive period, what would have been your exclusive period from your agency agreement.
Yes.
So
Correct.
just making that clear that it wasn't outside of it, wasn't saying about introductions, it wasn't any of that. It was sold during that, which comes right back to that warning that is in the agency agreement.
Yes, that's right. Staying with the first round, so this is before NCAT. And ultimately, member George determined this application by the vendor. But for Rain and Horn, not only did we make Ben give an affidavit, but also the salesperson that was involved. And he is relatively new to the industry. So I think it was a wake-up call for one of your salespeople, just the process of when it goes wrong. How did your agent deal with that, and having to not only work their sales listings, but then also have to deal with us and preparing evidence?
Oh, look, I think it was a real wake up call for him, and especially knowing that it was a childhood friend that he'd gone to school with, and the just blatant lack of disrespect around the agreement in the beginning, and him, or the client in question, completely lying about what did and didn't happen throughout the process. I think it was a real eye-opener for Sam. I don't think it's something that he'd like to go through again. But equally, I think that as a principal of an office, you've got to protect your staff and their fees. And we were adamant that we were going to pursue it, even in times where he was in doubt, because there were things happening outside of the real estate world as far as relatives of that particular client that were threatening that particular agent outside of the business. So he was just prepared at some points to just throw the towel in. But Lisa and I were pretty defiant on pursuing it, and he jumped on board, and we carried him all the way through. So I think he's glad he did it in the long run.
And do you, I think it's a good wake-up call where it's reinforced to sales agents the importance of all the things that we bang on about in the offices. That you got to get the paperwork right. You've got to have the checklist. You've got to do the market appraisal. You have to update the comparables. You have to have all this information done, and everything has to be documented correctly, because that was the process when we were involved with NCAT, was going back right to the very beginning. Every meeting, every communication, looking at text messages, everything, and then piecing together a case. So although I think a lot of agents think, oh, this is just a waste of time, it's not, and it's really important if you are involved in litigation. So in the main proceedings, the tribunal identified a number of key issues for determination, and this will run consistently for any agents that are involved in these types of commission reviews through NCAT. The first issue for determination was, did the respondent, which was the agent, comply with the relevant requirements of the Act and the regulations? So this was Rain and Horn. So did they do what they had to do? Did they present the right agency agreement? Did they have all their checklists? Did it have a cooling off period? Did the agency agreement comply? So in this instance, Rain and Horn were using an REI agency agreement. It was what we would term a standard form, so there was no nasties in it. It was written as a consumer contract. It had everything in it that was required, and there were findings that Rain and Horn did fully comply with their obligations. The next allegation that was made, and an issue for determination, was whether or not the vendor made a mistake in signing an exclusive agency agreement, because that's one area that can bring about a termination of a contract if a mistake has been made. And this goes back to what we were talking about, making sure that you have all your paperwork and all of the things that you're required to have in your sales files documented. So we were able to show through all the communications and how this contract, this agency agreement contract, was presented to this vendor, and the time they were given to consider it, and how they went about executing it, and consumer guides and the like that were given with it, that there was no mistake. There could not be on the evidence any mistake by this vendor. And so that reinforces having systems in your office and following these systems. It's all part of these supervision guidelines, and making sure you are doing everything that you need to do.
And that it's written and documented, and you can actually go back and find it when you need to find it.
That's right. We couldn't put evidence on that recounted conversations from 3 months earlier, because having a contemporaneous document that is prepared at the time, or an SMS message or an email, those documents speak for themselves, and they're easy in evidence to annex to affidavits, and to show what was going on at that time. So it's very, very important that this is all documented. The next allegation that was put an issue for determination by NCAT was whether or not Rain and Horn acted unconscionably by entering into an agency agreement. There were findings that Rain and Horn did not act in that way, and had done everything that should be done, including when the member was drawn to Rain and Horn's conduct in not letting the vendor out of the agency agreement. There were no adverse findings made against Rain and Horn because they'd acted properly. They're in the business of providing real estate services, so they're not a charity. And the tribunal and the courts give efficacy to business contracts, so that if people enter into contracts, they should be upheld. So there were no adverse findings against Rain and Horn. The next issue was whether or not the vendor was entitled to terminate the contract. And essentially, the vendors can terminate your contracts, but that doesn't terminate the rights. So any termination is without prejudice to the rights, and those rights are the period of exclusivity. So if you sign a vendor up for 90 or 120 days, they are exclusive to your agency. And so it's important, if agents make a call that they're going to allow a vendor to withdraw the property from the market, we're not calling that we're letting you terminate the agency agreement. Okay, we accept that you're going to withdraw it because you don't want to prejudice any rights. And Rain and Horn Monavale acted perfectly in that regard. Next issue, which gets to the heart of the section, was is the respondent, who is Rain and Horn, entitled to any of the commission as specified in the agency agreement? And there were findings that Rain and Horn were. But at NCAT, when you have a Section 36 review, they don't make an order that the applicant pay the respondent. What they do is they review the commission and then they either reduce it or they don't. But the agent doesn't walk away with an order that they have to pay the commission. Okay. So it's a bit of a lapse there, but nonetheless, if there was a commission review and the respondent upheld the review, as Rain and Horn did, they can then sue on their contract. So it clears
another step.
Yeah, it clears the path. It's our experience that most vendors pay it. And ultimately, what this matter went on to become was then about costs. Ben, before Member George made her determination, you're subject to cross-examination. How did you find that?
Yeah, it was fine. Look, we were just telling the truth, so I was okay with it 100%. I think it was very difficult for the vendor. I think he found the questions a little more difficult than us, but honestly, we just went in with the truth, and it wasn't that hard.
Yeah. So Rain and Horn were successful. Now, ordinarily, NCAT is a consumer tribunal, and it's meant to have mechanics and be an avenue for people to take smaller matters, keep them out of the courts, and be able to go to a tribunal. It's meant to be fast and cheap and move fairly quickly. And so this is the purpose behind these commission reviews for vendors, that they don't need lawyers. In fact, I won't say that it's actively discouraged at NCAT, but, you know, what's the old joke about lawyers being handbrakes? It's meant to it's meant to facilitate people could self-represent.
It's meant to be a consumer forum.
That's right. So a vendor can go and say, look, I want it reviewed, and not know every single case on it, but just tell their side of the story. Now, in this particular matter, Rain and Horn sought leave to be legally represented. That leave was granted. The applicant self-represented, and that's perfectly normal at NCAT and quite often happens. But of course, costs will run up. So the respondent was wholly successful, and ordinarily follows that costs follow the event. Now, particularly with NCAT claims under $30,000, it is unusual that costs would be awarded, and the value of the commission in this case was under $30,000. But nonetheless, being aware of the fact that there was an indemnity by the second agent that sold it, we sought orders as to costs and made submissions, and we drew to the tribunal's attention in our submissions that in circumstances where a consumer claim is tempered by a full indemnity by a second agent that knowingly enters into an agency agreement and encourages a vendor to do so and indemnifies the vendor, in those circumstances, the respondent should be awarded their costs, and that there are special circumstances occasioning the costs to be ordered to Rain and Horn at Monavale. Now, ultimately, Rain and Horn Monavale was successful and did receive a costs order in these proceedings. And what is of interest is comments made by Member George in relation to the conduct of the second agent. And they are akin to whether or not it is appropriate in circumstances where an indemnity has been given by a second agent that a consumer apply to NCAT, as is their right, to have a review when it never arises that the vendor would be out of pocket or liable to pay the commission for which the review is sought. And I think that's very important because our law firm sees a lot of instances where agents are out there giving these indemnities to vendors.
Indeed. It's talked about all the time.
Ben, you must see it a lot on the Northern Beaches, these indemnities by the second agents. What's your experience with them?
Yeah, I think that they're disruptive and destructive. So it does happen. There's particular agencies that do it. Like, we would never do that. It's just not something that we're interested in. Like, working on a property and selling it, only to be found later that we're at risk of losing the commission. And I just think it's disruptive to the industry. So I don't think it's a good tactic at all.
Yeah. Yeah, it was expensive, and we never got to see the indemnity. What we know about it came out of cross-examination of the vendor, but we never got to see it. But in circumstances where the agent gives a full indemnity, that means they're picking up the legals as well, that were ordered against the agency, against the vendor rather. Not only that, Ben, you just said it. You do all this work, you run it through a campaign, and there is a lot of work that agents do to complete sales and get them through. You do all the work and then you get nothing in the end. So I think that agents generally should reconsider this position of giving full indemnities because the tribunal's aware of it. Where it gets raised and it's put into evidence, you've now got this decision where it's the first time really the tribunal's had to grapple with it, and then have said this isn't really the forum for that, because you don't end up out of pocket. You're here for a review, but you're not paying anything. So I think there's an opportunity to reconsider it. The other important message I think to get out there is to say to everyone who's watching, this office, and I'm glad that Ben's come along today, but this is a big office and it's a well-run office. Ben, you're going to correct me, but top 25 REB New South Wales, 49 Australia in REB, multiple awards with Rain and Horn. I mean, you know, schmuck.
Principal dollar value.
Yeah.
Rain and Horn Network. It's award after
award. Award after award.
So it's a well-run, successful office.
To do those types of figures, get that recognition and peer recognition, not only just your GCI, but your peer recognition as well. That means that they're running a good systemised office with checks and balances. And this is the example where everything that they do and painstakingly, you know, checklists and writing everything down, you know, it bore fruit with this, because we were able to pull all the evidence together and defend that contract, that agency agreement and the commission. And it's a big well done to the entire team at Rain Horn Motorvale, because excellent job, really just followed through. Everything that we needed was there. And then it was a matter of just litigating on the contract. So big well done.
And likewise to you, Lisa.
And I think you sitting here listening to the pair of you talk about this is amazing, because what it's also saying is, Ben, and you've said this without putting those actual words around, is not every listing is, you know, it's not a listing at any cost.
Yeah.
So, which is, you know, an agent giving out an indemnity is kind of, I'll take any listing at any cost. Yeah. Whereas you'll take a listing if you're acting in the best interest of your vendor, obviously, because that's your fiduciary duty, but it's also about the best interest for your organisation, because that's your job.
Absolutely.
And to list and sell property on behalf of somebody else. And if you're doing that well, it's not about, well, oh, yeah, okay, we have to be careful here because we may not get paid, so maybe we won't give them the full service. So I think that's really important, that you're right in saying it's something that you just don't do in terms of giving out that indemnity. And I think
with a lot of agents that do those indemnities too, they don't actually think about the effect that it has on their client, because the amount of stress that it put that particular person under, I'm sure if he had it second time round, he would have never taken that avenue. And this is an agent that was a supposed family friend, and it just led to something that was not in their best interest.
Yeah.
And surely that's what we're meant to, you know, we're all meant to be doing with every client that we come in touch with.
Look, that's absolutely correct. But I just think it's very important where we've got supervision guidelines, and we've got a lot of requirements and compliance requirements. In fact, in the judgment, It actually notes how regulated the real estate industry is and everything they've got to do.
Yeah.
So anyone watching this thinking, oh my gosh, another checklist, more paperwork, this is ridiculous, just let me go out and sell. It's not just that.
Yeah.
You know, there's more to it. You've got to have everything done and you've got to have a good system. So in this one, sending the agency agreement off via email, and as Ben said, allowing the vendor without the agent there in the living room, time to read it and actually digest it.
That old line of, press hard 3 copies, sign here.
Yeah.
We've heard for 50 years.
Yes.
It's actually saying in your own time.
Yes.
Take your time. You've got a consumer education guide. You've got all of the things. You've also got a 1 business day cooling off period.
Yes.
So it's all of that in there for the vendor. And it is putting a process around it, and that's what the supervision guidelines are. Putting a process around it that actually works for the agency and works for your client. Yeah. So really important.
Well done. Well done,
and to you.
Well done to Raymond Horn at Monavale. Well done to Lisa Jemison from Jemison Fisher. And guys, let's hope that you won't have to be doing this ever again. But thank you for sharing it with us, both of you. And let's hope that lots of other agents can learn from this in terms of learn from the stress that you've been through, Ben, and the process that you probably didn't need to know all of that ever in your life, but now do. That other agents can learn from that in terms of how they follow their procedures and protect themselves whilst providing a really good service. So guys, thank you very much for sharing.
Thanks, Rosie. Thanks, Lisa.
Thanks, Ben. Thanks, Lisa. Bye now.
Thank you.